Hello, if the presentation has started, I don't think we have an audio feed. It might be muted still.
Sorry. Can you hear me now?
Yes.
Yes, thank you.
Okay.
Thanks for telling us.
Sorry. Thank you. Okay, as far as AV on the foreign sites, there's 9 states that have passed laws, and then a bunch of others that have proposed bills in the works as well.
And this past a few days ago, Maryland passed out of it hasn't been signed into law yet, but they passed a similar, they call it the Kids Code, but it's similar to the Age Appropriate Design Code. And we'll talk about that more, but we'll go through these different topics and then circle back for more.
I think the presenter device has lost battery because I just saw a message on the screen there from the presentation side.
Oh, that would explain it.
Yes.
I sent a text to Tony letting him know that their laptop had died and they may not be aware of it.
Oh, amazing. Thank you.
Sorry, there was some technical issue, but yeah.
Awesome. Thank you.
Okay, can the remote people hear us again?
Yes, thank you.
Yes, thank you.
Sorry, the computer just rebooted itself.
Awesome.
Okay, so we're back.
Yes. Now on to COPPA. So COPPA is the Children's Online Privacy Protection Act. It's been federal law since the 90s in the US. And there are multiple ways in which age assurance or estimation comes into play for both adults and kids. One relates to their requirements that covered entities obtain verifiable parental consent for under 13 to do certain things with kids' data. So they have to evaluate whether that person providing consent is an adult or is the parent. Second is there are certain requirements for mixed audience websites. So YouTube, for instance, is like a great example of having different kinds of content that might not always be purely directed to children and purely for adults. That relates to the third category of where this comes into play, which is determining whether a site is directed to children or is actual knowledge that children are on the site as defined by 13 and under. And the last thing about COPPA is that this past month, the Federal Trade Commission, which is charged with rulemaking to enforce the law, there was a, I guess, 4 or 5 year long process to do a rulemaking to modernize COPPA. And the comment period closed about a month ago. So there were some really interesting updates to modernize COPPA through that rulemaking. Our organization sent in a comment, and I can, go over and speak to what those efforts were, if that's of interest to any of you also.
Yeah.
And there's been a slew of litigation in the US this past year, honestly, challenging different types of state laws related to kids' online privacy and safety. The California Age Appropriate Design Code was challenged and is pending in the 9th Circuit, seeing what will happen there in California, as well as Texas law and NetChoice, which is a trade organization representing the large tech companies in the US, has been pursuing these lawsuits. And Texas and Arkansas and Florida and Utah, like there's different kind of flavors of state laws related to restricting the ability for minors or teens to access certain content online. And some involve strict age verification, some are more focused on parental consent. And then the age appropriate design code in California is similar to the UK age appropriate design code and similar to the one that was just passed in Maryland a few days ago. And then this isn't on the slide because it's more breaking US news, but on Sunday, a bipartisan bicameral proposed federal law, the draft text was published on Sunday. That I know so prior to this, in the past few years, ADPPA, the American Data Privacy Protection Act, was stalled and pending in the House and didn't really go anywhere. And then, yes, for 2 days ago, this new
I think we might have lost them.
They've had no luck, have they?
No. It'll be interesting to see if there's any traction on this, the data protection law. 48 times a charm, I guess.
if it deals with, and I do obscenity like this, it's a broader category. Sorry, I hope this works.
Yeah,
Thank you
unless
for
I
dealing
can
with
go
that.
down.
I think the social media laws, I mean, it seems to restrict First Amendment, or at least bring First Amendment scrutiny, right? So the first step is evaluating whether or not a law may violate First Amendment, and then there are different levels of scrutiny that a court can apply in balancing the governmental interest versus how it's infringing on what's first, or a company or business person's First Amendment right first free expression.
It's like,
So I think
all of a
that
sudden, 2 minutes
it'll be
ago,
interesting to see what happens with
like,
these social media laws. I think
it's done like
um,
three times.
even where there could be a First Amendment violation that requires some scrutiny, a lower level of scrutiny is appropriate for maybe a privacy law or impact assessment, like not what the California judge did, but I think that the social media laws are pretty extreme in some of those states, and I'm curious what will happen with the porn related ones. I know that Pornhub pulled out of Utah or Texas, excuse me. So there's already been some action there. But we'll stay tuned, and like you pointed out, the judges also, based on different circuits and environments, can rule differently, and it's not as consistent as we'd like to.
Against the background of the old copper,
Mhm.
having this impact essentially all around the world of that 13 age limit, to me, it might be an ignorant comment, but it's always really annoyed me because it feels like around the world, big tech hides behind that by saying, oh, it's fine, copper, 13, we don't have under 13-year-olds because of the lack of age assurance and so on. But just with that in the background, what benefits do you think either Copper 2.0 or any of these laws might have outside the States? Because they'll all have impact, but can you see any bits that could be really useful because they just filter out around the world?
It's an interesting question. I think looking at COPPA as it was passed was before many of the technology kids we use today was even dreamed about. It was mid-90s. So I think the idea of 13 being this age versus, obviously there's so much research now about age versus developmental status, things like that. And tech companies that many are based in the US certainly have an impact on trying to advocate for certain regulatory or legal or legislative changes. COPPA 2.0 involves an interesting aspect related to teens, different category between 13 and maybe 13 and 15, 15, 17, I could be wrong. And the Kids Online Safety Act, KOSA, which has also been proposed in the Senate, also has some different aspects related to teens and kids. I think, if anything, US is looking at the international community and what's already been done to try to see what we should do, as much as COPPA is something that's been in the US. I think what's important to also note about these legal challenges is that they're all pre-enforcement legal challenges. The laws that have been passed in many of your countries, we're evaluating the impact or the efficacy of how it works. And in the US, all of these laws are pre-enforcement, so it's hypothetical, saying this could violate the First Amendment, this might not be so effective, we're not sure. So if anything, I feel like it's an interesting flip looking at what's being done internationally to try to, I know that in a lot of the comments that people write in regulatory in rulemaking or when they testify from Congress, they'll be citing different studies or impacts coming out from international laws similarly.
Hi, I'm not sure. Are you taking questions now? We don't have that presentation back up.
Yes, yeah, basically we're in the Q&A part. So go ahead, please.
Okay. Yes. So in relation to COPPA, I was wondering if you could give us kind of an overview of verified parental consent, because I understand that I think if the FTC has said that there were certain methods that would satisfy verified parental consent, and if you could let us know if you know of anything being gestated in regard to that in COPPA 2.0. and then how you see verified parental consent intersecting the larger age assurance discussion we've been having at the conference.
Great questions. I don't know if there's any camera, if I should be looking anywhere, but so verifiable parental consent is an aspect of COPPA that it's not just parental consent, it has to be verified. There are certain methods that YOTI, for instance, a group that's here, has most recently applied to be approved as a method as an FTC approved method for verifiable parental consent. It wasn't approved for reasons I can go into, but there are, I think, so in the law itself, there's a list of approved methods. And then within the law, there is instructions for how a method could be approved and added to that list. And outside of that, you're not an approved COPPA VPC method. And as it relates to COPPA 2.0, I'm not sure how it relates to that as much, but when I'm referring to the COPPA rulemaking, the reason why I was focusing on that a bit more that the FTC just finished is because the US historically our Congress is often gridlocked and doesn't pass laws as frequently, but the regulatory process to do rulemakings to enforce the law in different ways is much more reliable in terms of, anticipating different, certainly like compliance aspects, but just being able to foresee what's coming. And so the FTC has been working on this rulemaking since I think 2019. And so if the rule is finalized, then that might have an earlier and more important impact than if COPPA 2.0 ever, makes it out. It's not there's no House companion, it's just in the Senate right now. So within the rulemaking, the big update related to verifiable parental consent is that there will be an added requirement for additional verifiable parental consent prior to an operator sharing personal information of a child with a third party. And the point of that is to introduce some friction into the data flow to third parties. The big issue that we flagged in our comment is that the way and this is getting into the weeds of it, but the way that third party is defined in the rule and in the statute excludes operators. And operators are just entities that collect and analyze information. So the issue there would be that some ad tech tools or entities that could be defined as an operator are left out of the third party definition, and therefore there might not be required to have additional verifiable or parental consent before sharing that information. I know that's a lot to take in, but the law wasn't written, again, like you mentioned, it was written a while ago, so it needs some updates. Sorry.
That's great. And I just wanted to ask you a follow-up. And are methods approved or are entities approved? In other words, was YOTI's method shut down, or was YOTI shut down as a provider of the VPC service?
So it's both. In the law, I should have had it in a slide, but there are methods that are approved. So I think it's so old, but I think there's like a telephone number, like there's things that are written that are not connected to a certain entity providing that method of VPC. And I think Privios is one that's approved, and it's the specific method that they were applying with. So the application that YOTI provided was about face estimation, not anything to do with verification. And it was that specific method that YOTI applied with. It wasn't YOTI generally, if that's helpful.
Yes, and I know that there was a company called Super Awesome, for example, that did a lot of verifiable parental consent. And so I want to be totally clear about this. So a company approaches the FTC and says, we want to do verifiable parental consent with this method that you have said before in a list is acceptable. And they review that as an application and then say yay or nay as to whether or not they are permitted to provide the VPC service with the proposed method.
Yes, it's a whole process where not only is there a formal application, but then there's a comment period from the public to comment on whether or not the FTC should approve that method. And there's mechanisms by which the FTC evaluates it. And afterwards, it would be listed as an approved VPC method by the FTC.
But if another company came along with the identical method, would they have to get FTC approval to provide the service?
It depends. Like some of the applications have very like they'll have proprietary technology or specific things related to the method that would make it unique. But again, there's methods that are included in this VPC category that are not connected to any entity or operator. Does that make sense?
That would seem to say then that if I came along with like the most plain vanilla 2000 era method that is old and established in the FTC, in the law, phone and utility bill or whatever, that I would, if I just followed that, would I still have to go to the FTC to get permission to enter the market
No.
to perform that service?
No.
No. Okay. So in a way, it's sort of like where it's a little bit not unlike the German method with the KJM, where you sort of get some assistance potentially by the other entity, the sort of the sector, the trade entity, and then you go to the KJM and ask for permission. Although in that case, you have to be always accepted as a provider, whereas in this case, you seem to be saying that if there's any variation in the method, that they have to go through it, and it's basically the equivalent of being accepted as a provider.
Sometimes it's not. Yes, that's majority right. It's based on the method, not on the provider.
Thank you very much. I appreciate the detail.
Sure.
What were the kind of common themes with the general public comments that were provided
On
for their application?
for the YOTI application, there were not many comments.
Okay.
It was I think most of them were provided were for, there was a range of them. Some were from some privacy groups that are it's hard for them to support any kind of expansion into biometrics, into age assurance. I think there's, without a comprehensive federal privacy law, it's different in the US. There's not, fewer things to fall back from, and it's harder generally to bring any kind of lawsuits against tech companies or other groups for, we can talk Section 230 if anyone wants to. But then there were other groups that, had, in our comment had, advocated that we weren't against it, but that there was some information regarding how data is stored and shared that would be helpful, that the FTC, we suggested the FTC get that information before making a decision. But it was not one of the more popular dockets. There was not many comments on it, as opposed to the COPPA rulemaking itself, which had thousands of comments from different kinds of groups.
I read the FTC decision as kind of a little too hard, too controversial. Let's kick it down the road a little bit while the assessment of the method is kind of underway. I'm just wondering whether you kind of agree with that general vibe. Just on what you said about more clarity over how the data is stored and handled. I think the FTC also put conditions on the method saying, okay, we approve it, but it needs to be done in this way.
Yeah, I think it was interesting to read. And I think that what the FTC wrote was relatively short too. It was, maybe a page and a half. I think it seems like they were waiting for the NIST guidelines to be published. But it was an important distinction that they rejected without prejudice, meaning that they could reapply. There's been other methods that are, use technology that's been approved by the FTC. So I really wasn't sure what they would, I assumed that the FTC would approve it. I wasn't sure what they would do. But I think the aspect of, doing it without prejudice, like reapply again, I feel like that was a pretty strong signal. They were not totally ruling, no.
Can I also ask, in the social media laws that you're seeing pop up across the different states, is there any distinction on service risk and are courts kind of considering risk that's present on a service as material? Because from our perspective, a lot of these laws just kind of apply a generic definition of social media, which is like peer-to-peer, this, and it doesn't actually talk about the standard risks that people can face on different media services. It doesn't account for different safeguards social media services have to prevent that harm from happening. And the policy objective of the law is to prevent harm to minors. You would think those considerations would be material rather than just having a blanket approach.
Yeah, I agree. From what I've read in those laws, the definition of social media can be really instructive, and it's often defined as a website, doing certain functions like you mentioned, but also serving a certain number of people. So whether it's a million or thousands, there's, you know, I feel like they're focusing on that. I haven't seen risk-based language in as much. I've seen some, you know, in the legislative findings that are published alongside with the law prior to the actual text of the law. There'll be some aspects of, you know, certain harms that can be outlined towards minors. But there's also, you know, the other parallel happening in the US is that content moderation on social media sites or just generally is another big legal area where it's unclear and it's developing how government can or should regulate that. So there's kid safety and privacy and also content moderation, and that's kind of merging in some of these lawsuits as well.
Hi, my name is Dr. Rachel O'Connell, and I'm part of the ISO delegation developing standards. And I just wanted, because this room is obviously interested in verifiable parental consent, we're bringing together a number of standards experts and standard bodies to write a technical standard that will define the levels of assurance that you can associate with the various methods that are out there for obtaining verifiable parental consent. So those will range from adult-child connection indicator, which would be possibly the EOT one, which would have a certain level of assurance, right up to verify when you verify the parental responsibility for a child. So we're doing it in the context of not only COPPA, but also GDPR Article 8, which says you must obtain consent to be authorized to hold parental responsibility for a child. So we're bringing together ISO people, and also it'll be led by IEEE, and also if anybody's familiar with the Kantara initiative, their consent receipt specification. So yeah, I just wanted to share that and take this opportunity. We'll be talking about it tomorrow, but as you guys are obviously interested, I think it would be good to share some information, and we will communicate some information about it through this summit, the mailing list, if anybody's interested. Thank you for the opportunity to share.
Yeah, of course. And I think you highlighted something interesting also related to prior questions about it, is that there's kind of two aspects of VPC in identifying if someone is of the age to be a parent or if this person has a parental relationship with the child. And there's challenges obviously in determining both and, you know, the mechanisms to evaluate that.
Yes, and I'm the technical author of the PAS 196 Age Checking Code of Practice, which was the base document that is now, we're discussing the age assurance framework. So your point is excellently made in terms of how do you determine, you know, where's the intersection between age assurance and VPC. And obviously, if you age assure, you verify this to be a 4-year-old. A 4-year-old cannot read the privacy policy, understand it, right? It's important. So there are key intersections there. So there would, yeah.
It's a challenge. Yeah.
It's a challenge.
So thank you for writing those technical standards.
Hi, I have another question if nobody else is currently going. My name is Gilad Rosner, by the way. I'm an independent privacy and identity researcher and consultant. So there was so in my prior research, it appears that there isn't a lot of embracing of probabilistic methods of age assurance in the US, that there isn't a lot of embracing of estimation. Actually, I have two questions, forgive me. And so, because in the state laws, they seem to be always looking for some kind of deterministic data, going to an ID, going to perhaps the state's version of a digital ID, going to a credit reference agency. But there doesn't appear to be embracing of the EOT style and Verify My style of facial age estimation. Would you agree? And do you see any changes? Have you heard of anything, any further discussions in legislatures that would seem to indicate more embracing of that?
I'll just answer that quickly. I think the design codes that were in California and was passed in Maryland as well is on its way. Hopefully, it can pass in Vermont. I think also Mexico. Those design codes are very age assurance focused. You know, with those kinds of methods being involved. I think the different kinds of state laws that require verification to like a harder age verification to have a social media account, for instance, or access porn, those are more verification focused. So I think there's a distinction there, between the design code bills, definitely being, interested, definitely more supportive for compliance purposes in kinds of age assurance methods.
Great, thank you. And then my second question was about, in the state laws, there doesn't seem to be a lot of privacy language. Like the Louisiana law and most of the porn-focused laws, basically, that are coming out. They don't seem to have a lot of privacy language in them at all. They don't seem to have any awareness of what they're asking for without putting guardrails. Would you agree?
It's an interesting question. I think some of the state laws have some good data minimization principles, which, we support from a privacy standpoint. But again, I think some of those, those laws like Louisiana requiring verification are more, in the US, it's a strange distinction. Some are, more kid safety focused and not privacy, as though privacy is not a part of safety, which it is. But either way, I think, I take your point in some of those laws not having as much privacy language, but I do think there is good data minimization language in some of those other privacy bills related to, obviously the collection, retention, sharing of data.
But nothing strong like thou shalt not use age verification data for other purposes.
There are some purpose limitations in the laws, yeah, but I can't speak that much to Louisiana. I haven't reviewed that one as much, but I find the design code laws to have stronger privacy protections.
Thank you.
I think the Utah and the Texas laws for porn have some clear kind of, you mustn't keep the information beyond doing the age check. So it's not just, don't use it for another purpose, but actually get rid of the data. And there's pretty big fines if you just store it beyond that check.
Yeah.
So I think there is some privacy in there, and there's certainly those two states have said facial age estimation is fine. And one of them has certainly said that's a key reason why we think you're not breaking identification and anonymity. But I think there'll be subjective views on that. You'll end up going up to the Supreme Court because you can't end up with different thinking it is identification or it is identification. It's one or the other.
Right.
Something I can make a decision about.
Yeah, and I guess that relates back to COPPA. If you, obviously federal law, if there's a conflict, will preempt state laws, and in COPPA, there are strict data retention aspects that you can't retain kids' information indefinitely. There was a FTC brought a really strong enforcement action against Amazon this past year for retaining kids' voice recordings to then train their Alexa model. And in COPPA, there, you can retain kids' information for a business purpose, but then not ultimately, indefinitely retain it. And so Amazon is arguing that training their models based on that voice recording was a business purpose, and the FTC in their enforcement action made clear that under COPPA isn't a business purpose such that you could retain kids' information indefinitely.
Can I just make a point, which comes up quite often? There's an assumption that age estimation is a more privacy preserving, than that age verification requires scanning government issued ID documents. That's not actually the case. You can do age verification in a zero knowledge proof approach or a hashing. So it can be very privacy preserving. You can also do age verification against authoritative data sources. So there's no document scanning whatsoever. So speaking, just a point that Gila raised, so I just wanted, because it's useful to clarify those points and make sure that our assumptions, to check our assumptions and not assume that age verification requires document scanning and is privacy invasive. When in fact the opposite. You can scan, you can check against authoritative data sources. Those data sources can be hashed, and the data that's being checked can be hashed, or you can use a zero knowledge proof. So there's been a huge amount of innovation in the whole age verification and age assurance in the last number of years. So it's good to kind of keep that in mind when considering the balance of rights and responsibilities. And the privacy protective natures of privacy enhanced pets technology to addressing age assurance.
It's a great point. I think I'm excited for continued use of pets in this area in the US. I think there could be way more use in the US.
The California ADC, when you look at it compared to COPPA or the ICO code, it's very brief. That's part of the problem with the Bonker case, but they also said that in scope, organizations could refer to the ICO website for more guidance. Are the other state laws doing that as well? Are they more expensive about what's required? Are they also referring to the ICO website? How are they comparing?
I haven't seen other laws for the ICO website. I know that Vermont and Maryland text don't. But I think in drafting legislation, it's always interesting to think about whether because sometimes a brief bill, can be challenged for the brevity in some way, but sometimes the opposite can happen where, if it's too long, there's other things to pick out as well. I think, quite frankly, there was going to be a challenge anyway to that law. But I think the way in which the district court judge evaluated it, it's, like I said, it's interesting to see what the Ninth Circuit Court will do. I think even if there is a First Amendment analysis, it doesn't need to be a strict scrutiny analysis that the district court judge had. I think a more appropriate analysis hopefully is done at the Ninth Circuit level.
Is California being added to the original legislation to make it more detailed and accurate?
I don't think they've touched it since, but if they're thinking about it, I'm not sure.
Rachel's point is a perfect segue to the topic of MDLs and digital wallets and using them for age verification or age assurance more broadly. And I just wanted to sort of get some of your views about how you see that entering this space. Because, for example, we know that Apple is building, if they haven't launched it already, the ability to verify your age through the MDL that they hold in their wallet. And in theory, that could have a bunch of privacy preservation techniques thrown onto it. It's not a decentralized model, it's a centralized model, but still they can do things like over 18 claims without the birth date. And they could go the distance and also make it further unlinkable to an identity, but that seems unlikely. So yeah, Google Wallet also starting to now get state MDLs. And so I just wanted to sort of raise that as a topic area and get your impressions.
Yeah, I don't really have any impressions on that yet. I feel like there's a lot of digital ID things emerging in the US, also in the immigration space, in the policing space. So I think the momentum that these different state laws or that a federal law might have related to kids' privacy could impact that, but it's so hard to say what will legislatively move forward. I think the COPPA rule also, once it's finalized, will get challenged in the courts, and then it's unclear how the courts handle it. So I hate to keep providing the I'm not sure answer, but I'm not sure. But if anyone else here has a thought, it's it's a great time of discussion. Well, any other questions? Any other thoughts?
I'm not too familiar with this. So the finding the parental consent, but we need to consent to the child actually taking the information in the first place. So at what point would that kick in? Because I know usually verified parental consent is that the parent is verifying the sort of way traditionally that the child is of a certain age. But with an automated system, I assume I wouldn't need to be asked if my son is allowed to use an AI to estimate that he is in fact 10, although I am his parent, so maybe I don't want him doing that, and I don't know how. I don't know. Yeah.
Yeah, no, it's a great question. So on a basic level, the verifiable parental consent is required for an operator, which is either its website is directed to children, or is actual knowledge that children are on the website as defined under 13. So to process their data, right? So if this website or entity that knows that is directed to children or knows that it has actual knowledge that there are children on the site, then there would need to be verifiable parental consent before they process the children's data. So that was a long-winded way of saying, I know it sounds strange, but I think, yes, there's a world in which that prior to collecting and processing the data, that there would need to be parental consent.
But my question was more if an algorithm doesn't pertain to things, it's an immediate scan and it just puts you on a distribution and says they're a child.
Yeah.
Therefore, either reject or accept. Does that company, does the actual algorithm need the parent's consent for the child to use the estimation tool?
I think so.
So there's a step before the child's able to do that. So that's quite a lot of friction. Yeah. Okay. Thank you. I'm quite new to all this.
No, it's okay, and I didn't draft it.
Yeah.
Everyone's spending it, but it's complicated regulatory framework.
Can I speak to that? So if you have a federated model, so you verify once you've many points.
Yeah.
So, right, and that's where telcos play it, and ISP play an incredible, important role in, as Gil had mentioned about digital wallets and, the mobile operators native app. So that could be a location where these checks are done. And then every time your child goes on to something, you get an in-app notification. So you can say, yes, you know, you verify it. Right, so there are ways to do this, which would be pretty seamless from the user experience that would meet all of the requirements that are laid out in the GDPR, DSA and COPPA.
Yeah, no, that makes sense. Yeah, I just wondered whether or not, estimation could ever just be deployed so that, the child goes on the site and stick the face in the webcam and it doesn't matter who they are. Like, he can, in theory, do it without me. He's apparently passed and now he's online doing his thing. Or there always needs to be push notification going to me as a parent to say, I don't mind my son using this tool, because it kind of seems then, if you're going to make them do that, then I may as well just tell you that he's actually older. Anyway, thank you.
Yeah, there are social media companies where people put account bases in or get on the video to chat to each other, and their terms and conditions say that because they have an under 13 term and condition, they then have the ability to check whether they think you are. Because you're going to say you're over 13, but the science may very clearly show that you're not. So different regulators can have a different view as to if the child has put their face on an account and then starts engaging in video chat with other people and they're not meant to be on that site. Do you allow the company to basically make sure that its terms and conditions are honoured, but the regulator then requires them to leave the age check? You're going to close the account.
Right, that goes to the actual knowledge piece, right? So that's why there's kind of two prongs in how an entity is considered a covered entity. It's whether it's directed to children or they have actual knowledge. And so, that goes to your piece about having, some knowledge anyway.
I'm Chloe from TikTok. I just wondered how much is happening at the federal level. Obviously, these are state laws, and is there any kind of working on to drive some standards and from a federal approach? I know that it won't stop this with individual state approach, but it might be helpful if there was kind of like a wider framework being developed more broadly to kind of introduce some consistency of standards in what we're seeing in the US.
Yeah, so there are two laws that have been introduced in the Senate side. One called COPPA 2.0 would update COPPA, and the other one with many different provisions. The other one's called the Kids Online Safety Act, KOSA, and those are both federal laws that have been talked about a bunch. And then a few days ago, there was a text introduced about a new comprehensive federal law. Literally, this was on Sunday. Called of the American Privacy Rights Act, which would preempt it's a very strong preemption provision that would preempt all state privacy laws. I don't know if that would also apply to state children's privacy laws, but there is not much in there related to kids in particular, so I'm not sure if one of the state, Senate proposed bills would be folded in or not. It's all very, developing. Yeah, I got off the plane and saw the draft text.
That's the way it goes with age, sure.
Do you have a view on, in the offline world, it doesn't matter whether a parent goes into an alcohol shop and says, trust me, my kid's over 18, and then gets the kid driven by the alcohol, they wouldn't bother doing it, and obviously buy it or get into them afterwards. The law just ignores that. It doesn't let a parent say this guy's over 18, and when all the evidence would suggest that human age estimation, checking their ID, or using a computer, the science would say it's a 12-year-old. So we're not going to accept your kid's view. Online, there's been discussion that one of the parents will give a false age to allow a kid to get onto a social media site, so they think it's maybe okay. But obviously you only have one age on the device from the parent, if it is the parent, and then you get to a point where the kid may be the wrong age, but the parents allegedly asserted it. Do you think there'll be a legal problem there? Is it the relying party says, well, look, how could I know? Apparently they are the right age, but maybe the evidence on the video face is completely not the case. Who would kind of win there?
No, I mean, it's a great question. And I think there's like a legal answer and also like a policy answer. So on the legal side, if this is like a COPPA situation, for compliance purposes, if you get the parental consent, then, kind of that's that. The actual knowledge piece applies just to whether, the child was on the website, not whether or not, the parent was doing, a certain thing. On the policy end in the US, there's a lot of conversation about parental rights and parents being involved and not discounting parents. And on the other side, I guess I'm calling it sides, but obviously it's not as cut and clean as one or the other. There's the idea that, many of these systems and what kids are doing online and the commercial surveillance system more broadly, the ad tech ecosystem is just beyond what anyone could really understand or meaningfully consent to for their child. And so I think looking at the design codes in that way of, having, or even this new COPPA update has obligations outside of the consent mechanism for data security, data retention. And so, that's different from this consent piece, the idea that, shifting the paradigm to some of these platforms to do certain privacy and safety safeguards and mitigation things outside of consent. So those are the two, answers I would give to that.
There's also an interesting thing in the DSA, the Digital Services Act and Online Safety Act, that introduce redress and other court rights settlements, which means that when you enable verifiable parental consent, and a parent has a consent dashboard, so they can see when and where they gave consent, and they know that the platform knew the ages of the kids. Then you rebalance the situation. So if the child then says, "Hey, this is what I've seen," the parent can say, "Okay, I'm going to go to the regulator or to the redress provider and say, on this date at this time, the platform knew that this child was this age. They've now seen all of this." So it creates a more balance. It's more of an equilibrium where the power is situated back into the hands of parents and stuff. And there's an ability for those redress processes to kick into place, as we have in the telecommunications kind of environment. So if you put money on your pay and as you go phone and it doesn't appear there, you can complain, and you have to complain to the operator. If they don't respond within 8 weeks, you can go to the regulator. So it's kind of mirroring those kind of redress processes. And for that to happen and for that to have teeth, then there is that additional element of the additional angle that verifiable parental consent adds to this is that ability to actually say, on behalf of my child's rights, I can now stand up for them and engage in a redress process, which is a newish angle. I'm not sure that exists in the COPPA. It doesn't.
Not really, no. I mean, broadly, anyone can file an FTC complaint. you know, like that. But then once you do that, you know, there's no obligation on behalf of the commission to do anything. Sometimes it'll start an investigation, sometimes it won't. But redressability is definitely a big issue in the US. And as I briefly mentioned before, section 230 precludes many lawsuits, or not precludes, you can sue a tech company, but often they're immediately dismissed in court if it's based on third-party information that's posted on the website. So that's an, you know, ongoing, really interesting issue for sure.
They're trying to keep looking in here. So one last question and we'll wrap it up.
No, but I wanted to react to that, so more globally in the Franco-French, where we have what is called the spirit of the law. So the spirit of the law is just like making sure that the ones that are very, very small do not get access accidentally, and that is most of it requires age cap that we're talking about. But if, I mean, the kind of cases that you were describing would be very little, or probably not so, not in such quantity that it would react and affect